Welcome to the Rockefeller Center, to Constitution Day, and to the Brooks Family Lecture. I'm Herschel Naklis, a professor in the Department of Government and the Rockefeller Center. It's my great pleasure to welcome you to today's conversation about conservatives and the Constitution with Professor Ken Kersch of Boston College. So a few words about the center, the Brooks Family Lecture, and most importantly, our speaker and our subject today. So for those of you new to Dartmouth, the Rockefeller Center for Public Policy and the Social Sciences, or ROCCI, fewer words, fewer syllables, is a home for public policy at Dartmouth. From classes and speakers to leadership programs, internships, and grants, it's a home for rigorous, nonpartisan, and practical engagement with essential issues of policy and governance. Constitution Day, of course, commemorates the 1787 ratification of the US Constitution on this day, September 17th, 232 years ago. Now, the celebration of Constitution Day at most colleges and universities, though, has only been sort of a phenomenon since 2005 when the federal government required it. Now, our public policy students will know what such a requirement sounds like. Constitution Day is indeed an unfunded mandate. So we're quite fortunate then to have the generous support of the Brooks Family Lecture Series to host Professor Kersch here today. The Brooks Family Lecture Series was generously established by Dexter Brooks in 1990. He's a member of the Dartmouth College class of 1947 and the Tuck class of 1949. And we're fortunate today to have Dexter Brooks' daughter, Dr. Wendy Brooks Harris, with us for today's discussion. Now, few subjects are as essential to contemporary politics and policy as conservative constitutionalism. We see evidence of this everywhere, from recent fights over the Supreme Court nominations of now Justices Gorsuch and Kavanaugh and associated theories of originalism, to the president successfully adding over 150 judges to the federal bench using lists compiled by groups like the Federalist Society, to live constitutional contests over the regulation of economic markets, administrative agencies, and religious practices, just to name a few. But what exactly is conservative constitutionalism? Is it a single coherent entity, or are there constituent strands and tensions among them? Where exactly did conservative constitutionalism come from, and what does its history tell us about its present and its future? Ken Kersch is an ideal authority to help us answer these questions. He's professor of political science at Boston College, a leading scholar of American political and constitutional development and American political thought. He's the author of 4 books, the winner of three major awards from the Supreme Court Historical Society and the American Political Science Association. He's taught at BC, Princeton, and Bowdoin. He's a graduate of Williams, Northwestern, and Cornell. And most importantly for today, he's published a brand new book, Conservatives and the Constitution, Imagining Constitutional Restoration in the Heyday of American Liberalism, which I highly recommend to everyone. It's fantastic. If you won't take my word for it, take Cass Dunstein's praise, who said, quote, "This is an excellent and illuminating new book," but notes that it is a work of history, not a work of advocacy. So Ken will talk about this for about 20 minutes. I'll ask him a few questions for about 15 minutes, and then we'll open it up to all of you to engage in this discussion. So please join me in welcoming Professor Kersch back to Dartmouth.
It's wonderful to be back here. I'd like to thank Dartmouth, the Rockefeller Center, and the Brooks Family Lecture Series. I'm very happy to be here. In our politically divided country, is there a bit of an echo there? In our politically divided country, one of the things that all of us, left, right, and center, and none of the above, can agree on is that one of the great political strengths of the modern American conservative movement has been its ability to unite behind clear, pithily articulated principles and positions, to sharply distinguish those from the positions and worldview of their opponents, and to take their distilled message directly to the people. From the founding mission of the conservative movement's flagship journal, National Review, in 1955, to the Sharon Statement of 1960, of the seminal conservative youth group, Young Americans for Freedom, to Arizona Republican Senator and 1964 presidential candidate Barry Goldwater's Clarion Manifesto, The Conscience of a Conservative, to Newt Gingrich's contract with America in 1994, the movement was drawn to declarations and pledges announcing that upon this rock we shall stand and yield not an inch, so help us God. And no rock did the modern conservative movement stand so tall and firmly upon than the rock of the Constitution of the United States. This was not the Constitution in some vague sense as a set of abstract goals or a flexible blueprint for government. It was rather the Constitution as fundamental law, the country's own, perhaps divinely inspired decalogue, setting legal metes and bounds beyond which American governments had been commanded by the sovereign we the people never to stray. When it came to the powers of the national and state governments to legislate, regulate, and administer, 20th century progressives and liberals didn't like to speak about the limits imposed by an inflexible fundamental law. They staked their claim on the ability to solve problems and get things done, to realize people's current wants and hopes and answer their purposes in the here and now. Progressives demanded a sense of purpose from their government, the conservative Jewish theologian Will Herberg explained in the late 1960s. But Herberg countered. The demand for a sense of purpose is a radical departure from our basic constitutional system. The federal government is not and was never meant to be a moral agency to give the people an inspirational lead. The government was not there to lead, inspire, innovate, motivate. It was not there to solve problems. Its work was, by design and to good effect, limited, small bore, and routine. When we talk about conservative understandings of the Constitution today, the appearance of unity and clarity on the right is perhaps even more pronounced. Studies of contemporary public opinion have shown that if there's one thing most people know about conservative understandings of the Constitution, is that conservatives stand on the rock of originalism, or the view that judges should read the Constitution by the lights that the nation's founders understood it. Some of the hottest topics in contemporary constitutional theory, constitutional history, and constitutional politics today are originalism, the history of originalism, the conservative legal movement and its mobilization around originalism in formulating litigation strategies, vetting federal judges, including appointments to the US Supreme Court. The interesting thing about this, from my perspective, and something I emphasize in this book, is that none of this work on originalism, and not even originalism itself in the way we currently understand it, dates back much further than the Reagan administration in 1980s. It begins just a bit earlier with Harvard legal historian Raoul Berger's Jeremiad against liberal judicial activism, unleashed by the Supreme Court's Brown versus Board of Education decision in his bombshell 1977 book, Government by Judiciary. And it dates back also to 1982 with the founding of the legal world's premier association of originalist lawyers and legal scholars, the current vetting group for all Republican legal appointments, including to the White House, the Justice Department, and the federal judiciary, the Federalist Society, right? Which was founded at Yale and the University of Chicago Law Schools, right? The stars of this mobilization behind the banner of originalism are well known to initiates, right? Not a few have been public figures. Ronald Reagan's close advisor, White House Chief of Staff and Attorney General Edwin Meese, his thwarted Supreme Court nominee, Robert Bork, who incidentally was the original faculty advisor to the Federalist Society at Yale Law School, right? And Supreme Court Justices Antonin Scalia, who was the original faculty advisor for the Federalist Society at the University of Chicago Law School. Clarence Thomas, Neil Gorsuch, and in sometimes mongrelized form, most of the reliably conservative appointees to the current Supreme Court. One of the major arguments of my new book, however, is that confining our understanding of conservative constitutional thought to the current musings and prehistory of these contemporary originalists, Raoul Berger, Robert Bork, Antonin Scalia, Edwin Meese, Clarence Thomas, to confine our understanding of this to them is a mistake, right? It's a mistake both for those who support the movement and for those who seek to challenge it. We would all be better off if we spent less time talking about post-1980s law school originalism, which is by and large a highly circumscribed debate amongst highly professionalized legal elites that seek a technical solution to the problem of judicial subjectivity, and more time talking about the more broad-ranging arguments and narratives about constitutional restoration and redemption within the post-World War II American conservative movement. The key point, and this is also a major point of my book, is that those arguments and narratives were advanced outside the law schools, not at Yale Law School, not at the University of Chicago Law School, but in the public sphere, and as such, shaped the main currents of American politics. So, my focus is one part on constitutional theory in the public sphere, and by public sphere I mean on radio, talk radio. I mean on television, in books, documentary films, mass circulation magazines. And one part constitutional theory as practiced professionally in academia, but in academia outside the law schools. Conservatives were excluded from the law schools. I mean, there were conservatives in law schools, but they were not teaching conservative constitutional theory. They were teaching property or trusts and estates or something like that. So we can look at academic theories, but it's outside the law schools. This is movement-based constitutional theory. And my book, I believe, shows that this constitutional theory was not only more sophisticated, but crucially, it was more transparently linked to the ideas, philosophy, and moral values of conservatism as a species of political thought. And it said so openly, right? The very purpose of later law school-based originalism is to deny its politics, right? It is the quest for a perfect theory that would produce a passive, objective, apolitical judge. That's what law school-based constitutional theorists do. And movement-based constitutional theorists are not playing that game. So it's much more transparent. The law school professors tend to erase, obfuscate, and deny the actual politics. In a way that would be highly indiscreet for a law professor, whose self-conception is that he or she is proposing a theory of law untainted by politics, post-war American conservative movement theorists openly affirm that the Constitution was a repository of substantive conservative values, debating in a law school idiom the respective claims of originalism versus living constitutionalism muddies the waters. It deep-sixes the underlying substantive nature of contemporary constitutional debate. Now, who are these people? Some of the names of the post-war conservative theorists I'm thinking of and discuss in my book are probably already familiar and well-known to at least some of you, perhaps even on par with Robert Bork and Antonin Scalia. So this would be people like Friedrich von Hayek. Even Ayn Rand talks about the Constitution, although no one ever reads her or says what she says about it. Milton Friedman. But most of the people that I discuss in this book would be less familiar. Ben Morrill, ring a bell? No? Martin Diamond, Harry V. Jaffa, Mel Bradford, Wilmore Kendall, David Lawrence, Edmund Opitz, right? Francis Schaeffer, John Whitehead, Fulton Sheen, John Courtney Murray, right? All of these movement thinkers thought and wrote extensively and highly influentially, if not about originalism per se, as we understand it today, right? Then about the country's abandonment of its constitution by modern progressives and liberals and the need of the right to rally for its restoration. I underline again, none of them were law professors, right? Many were journalists, they were independent scholars, and they wrote about constitutional abandonment and restoration in places like Reader's Digest, right? The American Bar Association Journal. The American Bar Association used to be conservative before the 60s, right? US News and World Report, and conservative magazines like Human Events, Modern Age, The Freeman, and National Review. Some were political science professors with training in political philosophy, often under the German emigre philosopher Leo Strauss at the University of Chicago. Many were evangelical, fundamentalist, or right-wing Roman Catholic clerics. Some of this is in theology, right? It's by theologians. If you want to read theories, often quite sophisticated constitutional theories of what the American Constitution meant to its founders once restored by conservatives can mean, and I would argue might very well mean again, by self-professed libertarians, moral traditionalists, and the shock troops of the religious right, you will find it here, not in the writing of conservative originalists today at America's most prestigious law schools, right? Now, there are many payoffs to shining a spotlight on this earlier movement-based intellectual and political mobilization for constitutional restoration and redemption, for conservatives and for their opponents. That's, I guess, Cass Sunstein's point, right? Thankfully. So there's something for everyone, almost everyone, or at least for the two sides if we're going to be binary about it. By getting to know this earlier movement-based constitutional theory, conservatives will gain new resources for deepening and broadening the range of legitimate conservative constitutional theory. Knowledge of the breadth and range of this theory is an antidote, at least for those who are open to taking it, for the much-noted epistemic closure on the right, which with its focus on fidelity and betrayal, loyalty and heresy, may in the short run be good for politics, but in the long run, I at least believe is pretty dangerous for the country. As for liberals and progressives, getting to know this earlier movement-based constitutional theory will provide an illuminating window on how movement conservatives actually think and see the world and its relationship to the founding and the Constitution that they will never get by following every last utterance on the originalist constitutional theory coming out of the law school. This will allow them to better fight their fight, since they'll at least be challenging something that actually exists, rather than lurching blindly and recklessly at shadows and chimera. Right? The illumination provided by looking at the movement-based constitutional theory stems in large part from the fact that it is not only history, it maps the conservative mind and thought of today's political and constitutional right. This thought has always been paramount to motivating and unifying the right's ostensibly diverse constituent parts. In the earlier period, it united the immigrant Austrian economists, the fundamentalist and evangelical Christians, classicist political philosophers, segregationists and white supremacists, sagebrush libertarians, disillusioned and wavering New Deal and Great Society liberals, Ivy League social scientists, Roman Catholic neo-Thomists, pillars of the bar, Main Street Babbitts, and business titans, Burkean traditionalists, and apostate ex-socialist and communist journalists. Right? Just as it informs and motivates and helps unite the diverse philosophies and identity groups that have formed the conservative coalition today. About this, again, law school originalism and reading about the founding of the Federalist Society in 1982 will tell you virtually nothing. Let me close with a concrete example of one post-war movement constitutional theory debate that took place within the movement and outside the law schools. Okay? In this case, in books and in the pages of National Review and Modern Age from the 1950s through the 1970s. This example, this concrete example, will both illustrate the diversity, pluralism, and even vigorous contention within the movement, a resource for conservatives in the way I describe, and it will also underscore the contemporary implications of these views in a way that would be very helpful to liberals and progressives who hope to fight them. So my example is the fierce debate between the 1950s and the 1970s between the movement's deliberate sense structuralists and its natural rights moralists over the nature of the country's constitutional foundations. To put names to these ideas, it was a fierce debate between Wilmore Kendall, Martin Diamond, and Dartmouth College's own Jeffrey Hart, right, on one side, and on the other side, Harry V. Jaffa, Charles Kessler, and other West Coast, so-called West Coast Straussians and Christian right thinkers. Okay? West Coast Straussians because this was based at Claremont McKenna College, right, in California, Southern California. The latter of whom, these West Coast Straussians, not coincidentally, I hope you will see in my brief overview of this, are the predecessors of, and in a few cases, the very same people who are the most fervent champions of the leadership of Donald Trump. Right? Unlike constitutional theory as practiced by law professors, the conservative theory I have just named spent little time and certainly didn't focus on judges. Right? Judges were incidental to it. It was not their main thing. That's another thing that's different from law school-based constitutional theory. They were focused on how we should understand the broader American constitutional system, or as Straussians would put it, the nature of the American political regime. In one quarter were structuralists like Martin Diamond of Northern Illinois University and the incendiary maverick Yale University and later University of Dallas political scientist Wilmore Kendall. Right? Both Diamond and Kendall emphasized the Constitution, as originally designed by its founders, had been aimed at realizing diverse and at times contending, if not conflictual, purposes set out in the preamble of the Constitution. So there's a list of 6 different objectives of the Constitution in the preamble. Kendall's view was that at different times, one of those would be more important than another, and they would shift in emphasis over time. To be sure, Kendall said, the founders were suspicious of direct democracy, but it was nevertheless, the Constitution was a democratic document speaking in the voice of the people in its foundational commitment to popular sovereignty, both in the country's constitutional institutions, the basic architecture of American government, and moving forward, allowing for change and development in the means to be enlisted as times changed and new problems arose, and in meeting the present needs of the American people. Drawing from Alexander Hamilton's Federalist 71 and 63, Kendall advanced a deliberate sense understanding of the American constitutional regime that authorized the making of new law only after proposed legislation has successfully run a gauntlet of checked and divided powers as set out in the Constitution's core articles. Right? Article 1, setting out the bicameral Congress's legislative powers. This is my Constitution Day lecture, as separated from the Brooks family lecture. Article 1, setting out the bicameral Congress's legislative powers. Article 2, setting out the president's executive power. And Article 3, setting out the judicial power of the federal courts. Running this gauntlet was not easy, Kendall and Diamond emphasized. It it provided, Kendall explained, that only those laws after deliberation and debate that had been distilled by the cool, deliberate sense of the community should govern the conduct of those to whom they entrust the management of their affairs. And Hamilton emphasized decidedly not, and this is Hamilton's language, proposed laws arising out of, quote, every sudden breeze of passion, every transient impulse which the people may receive from the arts of men who flatter their prejudices to betray their interests. As Dartmouth's own Jeffrey Hart, a Wilmore Kendall supporter in these debates, explained, in advocating for Kendall's constitutional theory in National Review in 1970, liberals had grossly distorted this order by overdeveloping the president's Article II powers and the judiciary's Article III powers at the expense of the powers of Congress as set out in Article I. Okay? But in mid-century United States, Jeffrey Hart, Wilmore Kendall, and Martin Diamond's constitutional theory was targeting not simply the views of liberals. Their major target was actually a rival tradition of conservative constitutional theory with many adherents in the contemporaneous conservative movement. That target was what they called the Declaration tradition, propounded by Claremont McKenna, Straussian, Harry V. Jaffa. Jaffa argued that the ultimate foundation of the Constitution was not structural or procedural. And by the way, they hated each other. This is to the death, right? Almost. The ultimate foundation of the Constitution was not structural procedural, Jaffa said. It was moral. It was first articulated in the stirring language at the outset of the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted amongst men. In practicing and tolerating chattel slavery, Jaffa argued, the American founders betrayed this bedrock moral commitment of the Declaration of Independence by belatedly putting these principles at the center of the American constitutional regime. However, Abraham Lincoln, right, had redeemed that regime. And crucially, going forward, only those who likewise affirmed and attested to the natural law and natural rights foundations of the Republic were held to have earned our approbation as genuine statesmen, guardians, and defenders of the American Constitutional Republic. Harry Jaffa's 1959 masterwork, Crisis of the House Divided, set out these understandings by an extended moral philosophical reading of the Lincoln-Douglas debates. Jaffa read those debates by lights of ancient Greek philosophy as one of the most profound texts in human history, in pitting against each other the respective claims of merely positive, human-fashioned law, what the majority of the people will, and natural, divinely ordained law, what was true, right, and good, or what the people should will. In the Lincoln-Douglas debates, Senator Stephen Douglas argued for positive law in propounding his theory of popular sovereignty, for whether there should be slavery in the new states and in the territories, right? His challenger, Abraham Lincoln, argued for natural law, insisting that the people had no right to enact any law that violated the equality of natural rights by providing for the enslavement of other human beings. To Jaffa, the deliberate sense structuralist understanding of the regime that was propounded by Kendall, Diamond, and Hart sounded a lot like Stephen Douglas and popular sovereignty on slavery, right? Whatever the vote comes out to, that's where we're going to go, right? And to Jaffa, this scented of might makes right. And the antidote was to this wicked capitulation was leadership by a virtuous Lincoln-like leaders and statesmen who ruled with the proper moral and philosophical foundations at the forefront of their commitment, men who put natural law over the merely human. Okay? The structuralists, in answering this, were deeply disturbed by the implications of Jaffe's declarationist tradition. To take another example, to add to Kendall, the movement's leading neo-Confederate thinker, Mel Bradford of the University of Dallas, in his own states' rights idiom, condemned Jaffe's declarationist tradition for its messianism. This is why you should always listen to neo-Confederates, by the way. That regardless of all of his appalling views on race and everything, I think he really had a very penetrating insight into what might be the problem with what Jaffe was saying. And he says, if you think of politics and the Constitution that way, you're going to be inclined to messianism about the president, right? That this is the president that is finally going to restore our natural law foundations, and we have to follow the dear leader in leading to this. So the crux of this criticism was not simply that it was a moral theory, but a moralistic vision and a Manichaean moralistic vision that placed too much emphasis on Zeus-like pronouncements, fiery biblical pronouncements about right, wrong, good, and evil, and who will lead us out of this sorry state of affairs. Bradford said this is going to lead us to self-righteousness, right? Moral leaders will seek to vindicate the declarationist tradition at whatever cost, right, with a sense of divinely ordained mission. It was a recipe for lawless Caesarism, for moral crusades, right, and for anointed great presidents who understand themselves, and this is Bradford, to be receiving regular intimations of divine will through prophets who arise to recall them to their holy mission. Okay? Although you would never know it from getting entangled in law school-based originalism, this West Coast Straussianism is today alive and well in places like the Claremont Review of Books. It's alive and well at the Heritage Foundation, and it is part of the common rhetoric, if you recognize it, in the daily patter of talk radio and Fox News, right? Indeed, these people are the most vehement supporters of Donald Trump within the conservative movement. And not surprisingly, they have spearheaded an extensive new corpus of conservative scholarship on chattel slavery and Abraham Lincoln. This is one thing that always gets me wrong when I hear about people on the left writing about conservatives and say, what about slavery, right? What about, these people talk about nothing but slavery, right? And they talk about nothing about except the Civil War and Abraham Lincoln, but the way they read it is that represented a standoff between might makes right, positive law, and divinely inspired understandings of right and wrong as vindicated by Abraham Lincoln. Now, slavery's been eliminated, right? So what are the current fights about right and wrong under natural law? Abortion rights and same-sex marriage. And in this story, right, it is liberals and progressives who are cast as Stephen Douglas. And it is conservatives, right, who are cast in the role of the abolitionists and Abraham Lincoln, right? And as you might suspect, I've so far been talking about Straussians, the contemporary religious right has found this high-order constitutional theory highly congenial, right? I'm a little over time, so let me just say very quickly, without getting into the details, the Declaration was also put at the center of Catholic right thought as well, which has its own natural law tradition. And that was also done in a classic book very early on in 1960 called, guess what? By a Jesuit priest called We Hold These Truths, right? So it fits in with that as well. Let me make one final observation and claim about the relevance of this earlier thought to the contemporary conservative movement. I began the lecture by positing a sharp dissonance or disconnect between movement-based constitutional theory and professional law school-based constitutional theory. My final claim today is that that wall that has long separated these two worlds that I opened the talk with is now beginning to crumble. Okay? This is because elements of the movement constitutional theory I described as taking place outside the law school is now being imported into the legal profession and the Federalist Society, okay? Which obviously has direct political consequences. So the Claremont Institute, the Center of West Coast Straussians, and various Christian right centers, which used to just focus on undergraduate students and PhD students in political philosophy, in the past 5 years or so, they've started training law clerks for judges. They've started training judges and law students. So the Federalist Society, this is ultimately going to make its way into the Federalist Society. And these people are now running boot camps for lawyers and for judges. It's always been something of a fiction, if not conceit, that law school-based originalism and movement-based constitutional conservative ideology and thought were separate and separable. Given their professional role, law school-based constitutional theorists will be heavily investing in maintaining the plausibility of that separation, right? But as the conservative movement, including the conservative legal movement, has abandoned theories of judicial restraint, right? Have abandoned law school-based theories of how judges should defer to Democratic majorities. And they have launched their own rights revolution, right? They now are looking for content to fill the content of those rights that the judges will fill in aggressively exercising judicial power and judicial review. And that content is very likely to come from this earlier and more substantive element of constitutional thought. Someday very soon, I think and hope, we will stop talking about law school-based originalism and about and start talk as if it were simply law school originalism, as if it were simply a matter of interpretation, and start talking about deep understandings and profoundly consequential understandings of American politics when we talk about constitutional law. And this is just another case of, if you really want to understand the future, you need to understand obscure elements of the past that have been involved in this movement from the 1950s until the present. So I'll stop there. Thank you.
We'll give you a second to have a drink of water. But I just want to thank you for a phenomenal talk and a perfect talk for Constitution Day. I'll just ask a few questions, and then we'll turn it over to hear what all of y'all have to say in response to Ken's talk. First of maybe 2 or 3 questions is about a particular example of the point you closed on. Because I think the point you closed on is exactly right, which is we're seeing now this sort of successful synthesis. And it strikes me that Justice Gorsuch is an underappreciated example of the very synthesis you described in closing. And this goes back to his days as a graduate student at Oxford, if not before. And I'm just wondering if you could sort of tell everyone briefly that story, because I think often Justice Gorsuch at least was sold in many ways as law school originalist, and there's a lot more to it that I think illustrates the very synthesis that you described.
Yes, so one thing I want to emphasize with this is obviously predicting the future is a dicey matter, and there are a lot of things going on here. So I don't want to imply a one-on-one direct connection. I just want to say that the different elements of what it means to be a conservative jurist are starting to shift kaleidoscopically. And certainly, we are more likely to see something new. And Gorsuch is a good example of that. One thing that almost no one ever talks about, as far as I can tell, is that Neil Gorsuch is the first Supreme Court justice with a PhD. And he also has a law degree, but he has a PhD in political philosophy. That's part of the point of this, right? Not only does he have a PhD in political philosophy, he studied under one of the leading Catholic right Thomist thinkers, John Finnis, at Oxford, right? So he's the first Supreme Court justice who is not just absorbing this incidentally or by thumbing through National Review, right, or scrolling through, however we do it these days, that he literally studied it, you know, and wrote a thesis on it, a doctoral thesis on it. So that is he is at least deeply, deeply immersed in this. I would note, incidentally, that so is Clarence Thomas in his own way. That these people increasingly are invited to speak at Claremont and the Claremont Institute. And Clarence Thomas's wife, you know, is obviously deeply involved in the religious right and has a deep sort of theological grounding in this. So right there, I mean, that's a direct influence on the justices. You know, I'm not implying that just because his wife believes it, that he believes it, but in this case, you know, they are on the same page in a lot of things. So some of this is that there is more of this natural law thinking generally in the air, but some of this is very direct, and I think Neil Gorsuch is a good example. Now, Neil Gorsuch is kind of on the edge between this, because he was also raised in the old Federalist Society. And I'm not sure which way this is going to go, but there is a strong new wind inside the halls of the Federalist Society. And especially now that they don't talk incessantly about the need to defer to legislatures and hold back on judicial review, I think there's a space for that wind to sort of rearrange the landscape.
I don't want to make this talk excessively about contemporary politics, because that would be the exactly wrong thing to do, but I'll do that briefly here. So the wind that you've just described, this strong new wind that's now blowing inside the halls of Federalist Society meetings that many of our students will be attending when they go to law school, it has often been said since the confirmation hearings for now Justice Kavanaugh that entire episode will provide a countercurrent to the wind you've described, by which I mean all the subjects that were the sort of focus of the debate around Justice Kavanaugh's confirmation, because of the intensity of that and the Supreme Court's strong desire to not look political, it will now sort of strategically retreat from the very domains that that wind might have been describing. It won't grant cert on cases related to Roe. It'll avoid sort of issues that might be seen as related to some of these traditions. Again, this is just a theory that's floated out there. Some people say evidence exists from it in the last term, but I'm just wondering what you think.
Okay, so I'm going to be sure. So the theory is that this was too scarring for the court to move in this direction?
Particularly related to sort of gender or religious liberty or whatever it might be.
Okay. The short answer is I don't know, but here are some thoughts, all right? Certainly the Chief Justice, John Roberts, although he's a very religious Catholic, he's a good example of, and actually I think Brett Kavanaugh was too, that there were always many religious Catholics in the Federalist Society. However, given their older generation, they were raised in the tradition of that's irrelevant, right? That essentially what matters is judicial restraint. The judges should be restrained. They should defer to the legislative branches because they're elected by the people. And I think certainly Roberts and even Kavanaugh were raised in that old school approach. And I think, you know, just personally, John Roberts has a very keen sense of himself as on a balance point in the court, struggling to maintain its democratic, its legitimacy, I guess is the better way to put it. However, I certainly don't think that Samuel Alito, for example, has any inclinations in that direction. Clarence Thomas obviously has no inclination in that direction. Neil Gorsuch probably has no inclination in that direction. One of the most interesting things about the Kavanaugh hearing to me, I mean, aside from all the stuff you already know, is that he also was a bit on a balance point, because I think he was an old school Federalist Society type who, when he got attacked, went identity group tribal, went, I loved my conservative Catholic prep school, and he got very much faith and family in a way that older school Federalist Society people would have never done. That is an identity-based argument, and it was advanced in an extremely belligerent, strident form. And I think that's what carried him through. I'm not saying it wasn't successful, but I think he departed from the template he was raised in. So I don't actually know where he's going to come out, but I'm just saying, to get confirmed, he had to go in that direction to say, I'm with the Christian right, I'm with the Catholic right, I'm with belief in faith and family after all, and I don't, being at a Catholic university, I hear a lot about faith and family. So I know what it sounds like. Again, prior to that hearing, I don't think he discussed constitutional issues in those terms. And so I don't know. If Amy Coney Barrett had been appointed, this would have been even more obvious. And she is someone who's deeply steeped in Catholic natural law thought. She's a law professor at the University of Notre Dame, which is not incidental, although it might be for some people. She's a conservative Catholic, and she's very deeply rooted in it. And she might be the next appointment. So I'm not sure where this is all going. I'm just saying that there's more in the mix than there used to be. Yeah.
Yeah, I think if Justice Ginsburg leaves the court in the Trump administration, that's quite likely to be the next appointment. One final question, then we'll turn it over to the audience. So we talked a lot about conservatives today, less so about liberals. So here's a question about liberals, which is, why has liberal constitutionalism, in my mind, why has it failed?
Oh my.
So here are three pet theories of mine. Maybe you disagree with the premise, but here are three pet theories that I'd love to hear your thoughts about, and then we'll turn it over to the audience. So it just strikes me that whatever one's politics, there's an intellectual heft to many parts of conservative constitutionalism and clear political success that is not mirrored on the left. So here are three potential reasons. The ideas are bad, the political actors behind it are lazy, or the political actors affiliated with it are focused elsewhere. So here's the ideas are bad theory. Maybe there just isn't anything really intellectually deep about living constitutionalism. Maybe there's just no there. Here's the lazy theory. Maybe in the period of restoration that you talked about, when there were no conservatives at Yale Law School was dominated by liberals. It was very contented in that dominance. There was no reason to try very hard. And so perhaps you might say that the folks that are in the liberal constitutional folks just got lazy. And by the time they were out of power, once Reagan comes along, that apparatus didn't exist. And then the third theory is related to that, which is just the liberals were focused on other stuff, this sort of Democratic Party rainbow coalition, and their limited bandwidth was focused elsewhere.
Okay. So, like all of these questions, it's very complicated, so I'll just venture a few observations on that. So there has been a lot of work on the 1930s and after by historians about what was mid-century American liberalism generally. And I'm thinking of a book by Ann Kornhauser, who's a historian at the City College of New York and the Graduate Center. And one thing she argues in the book that I completely agree with is that ever since the 1930s, I mean, the 1930s, the so-called Constitutional Revolution of 1937 that authorized the modern regulatory and administrative state, most of the resistance to that under Franklin Roosevelt was liberals were focused on eliminating the barriers that conservatives had put up in constitutional doctrine. And once they won, they never actually developed a coherent affirmative theory to bring forward. So I don't know if that's laziness or just lack of necessity. I mean, Franklin Roosevelt was elected to 4 terms. The liberal Democrats controlled both houses of Congress and almost every state house, probably every state house in the United States. What kind of new constitutional theory do you have to forge to get your way under that? And Roosevelt's appointees are on the court until basically 1970, you know? So I don't know whether it's lazy. They didn't have to do it, okay? Now, there was an even further liberal court, the Warren Court, in the 1950s and 1960s, that did lead to liberals to come up with new theories of individual rights. So I'm going to just say something about two of the leading schools of liberal constitutional theory that were the most intellectually serious in this time. And both of these, I think, are terrible, you know. It's not that they're stupid, it's that they have a really tin ear politically that comes with the arrogance of power, you know? That, you know, it's probably like a college campus, right? I mean, how many things can people on the left get away with saying? Well, it turns out quite a lot, right? Because, you know, they're in control of everything, right? So here's an example, and this is stupid liberal constitutional theory. And this is coming from Stanford, right? It's not that it's stupid intellectually. The main theory of liberals, the high watermark of liberal constitutional theory, was called non-interpretivism. And this is essentially a linguistic theory that language can mean anything. You know where they're getting this from? They're getting it from Jacques Derrida, right? They're getting it from French literary theory. So it's not stupid, but it's an argument essentially that who's to say anything in the Constitution means anything if you're a smart person and understand linguistics at its highest level? That may be the most sophisticated theory in the world, but it's probably not going to play in Peoria, right? It's a purely academic theory that is really dangerous. And that's the hole that originalism drove through and say, what about the text? You know, I mean, there were people arguing that the president has to be 35 years of age. Well, who's to say what 35 years of age is? Because, you know, people had different lifespans at that time, and what is meaning anyway? And, you know, it's all about power, and, you know, I mean, it was crazy. Okay, the other thing that's crazy, the other line of it, this is my own personal view. John Rawls's A Theory of Justice, which fed into constitutional law through Ronald Dworkin. This is essentially a theory that says, I'm going to put a blindfold on you. We're going to think about the powers of government. I'm going to put a blindfold on you, and you don't know where you're going to be in society, whether you're going to be rich or poor or anything. And you're just going to be kind of a cipher. And I'm going to play this thought experiment. If you didn't know whether you're going to be rich or poor, what are you going to do? What are you going to authorize for government and prevent government from doing? And then at the end of this, John Rawls basically says, this is amazing. It's exactly the platform of the George McGovern presidential campaign in 1972, right? Perfect fit, right? In fact, that's the only reasonable understanding of what government should do and should not do in the abstract, right? That is also extremely solipsistic and unimaginative. And it leads to things like people saying, again, this is arrogance, is saying, when conservatives and liberals debate, they're basically saying to conservatives, there is no possible reasonable grounds for anything you believe about the powers of government. So, by the way, we don't have to hire you, we don't have to talk to you because you're unreasonable, right? That works until it doesn't work, and then you're screwed. right? And that's where we are. That's where we are today. So I guess my answer is all of the above.
And on that note, we'll turn it over to y'all. So we'll go here and then up there. As always, we'll start off with students.
First, I would like to say that I thoroughly...
Oh, I'm sorry. Could you just wait for the microphone? Sorry.
I don't think I drank my wine.
First, I would like to say that I thoroughly enjoyed your talk. So thank you very much for coming here, and thanks to the Brooks family for bringing thinkers like you to campus. I have many questions because your talk was very thought-provoking, as well as the Q&A session, but I'll ask one two-parted question. You mentioned that there were not a lot of conservatives at law school for a good amount of time. So I was wondering if you could explain further on the roles conservatives have in academia. And second, I noticed that you spoke about law and politics sometimes separately, and I'm curious if you view this both, like if you view the two as mostly the same or very different. So yeah, that's my question.
Okay. Conservatives at law schools. So, I mean, one thing I did emphasize is that I'm sure there were conservative professors at law schools, but what they were not doing is teaching constitutional law according to conservative. They were not being innovative scholars in constitutional law, and they were not teaching constitutional law. So for our purposes, for purposes of this talk, it was pretty irrelevant. You know, I think the reason for that is probably not as obviously nefarious as, I mean, it might be the same thing that happens today in other areas of the academy. It's not that the liberal law professors got together and said, we're not going to have any conservatives here. I think they had a real sense of what the important academic and intellectual debates were, and who was on the cutting edge of those debates. And these people were, all of what they were doing was viewed as antiquated and beside the point. So one thing I want to note about, just to take an analogy, Ludwig von Mises and Friedrich Hayek, okay? These are two conservative so-called Austrian economists, right? They are both luminaries of conservative economics. In fact, Friedrich von Hayek in the early 70s won the Nobel Prize in economics. They could not get academic jobs in the United States. Both of them were hired by American universities. Mises was hired by NYU, and Hayek was hired by the University of Chicago. But neither was in the economics department. They were hired by private foundations. So it wasn't the Koch Foundation, but it was the equivalent at the time. Basically, a private conservative foundation paid their salaries, and the University of Chicago said, yeah, we'll give them an office somewhere as long as you pay their salary, because we're not hiring these people. Because what they're doing is irrelevant to what contemporary economists are doing. They're fossils, right? We did that in the 20s, right? It turned out, just like the thing I'm going to talk, what they were doing in the 20s turned out to be the 80s, 90s, right to the present day. But their attitude was, this is so stodgy and out of fashion that why should we hire these people? I think that was true. First of all, there was no conservative constitutional theory. And I don't even think that there was no one even doing it. I don't even think. The closest thing, and actually I didn't say this in my talk, but it's in the book, there were a few leading people who became identified with conservative constitutional theory who were very prominent in the law schools. One was named Philip Kurland at the University of Chicago. Another was Alexander Bickel at Yale Law School, right? But as it happened, these people were New Deal liberals who became disillusioned with liberalism in the 1960s, the late 60s. So they were already there as supporters of Franklin Roosevelt. They happened to both be clerks of Felix Frankfurter, and Felix Frankfurter emphasized judicial restraint. And the reason these people became conservatives, judicial restraint in the 30s used to be a progressive view. And the reason these people became known as conservatives is that they stuck with the progressive view of judicial restraint right through Brown versus Board of Education and the liberal rights revolution. And people started saying, even to Felix Frankfurter, you're conservative. And he would just get crazy. He's like, I trained Brandeis. I mean, I was a student of Brandeis. I was a huge FDR advisor. How dare you call me conservative? But when the court was deciding Brown, he's like, the court should stay out. That's what we believed under Franklin Roosevelt. And because he stuck to that, he became known as conservative. Okay, on law and politics, I'll just say very quickly. One of the pleasures of going to graduate school in political science after law school is I got to abandon the fiction of this separation between law and politics. Look, I mean, I'm a political scientist, so I believe that constitutional law is political. The one concession I'll make to the legal academy, and I'll say this as a little more as a historian, I'm a bit interdisciplinary, is that there are long stretches where things look apolitical because there's a consensus. So for all practical purposes, it looks legal rather than political. Once that consensus disappears, then it's obvious that it's politics. And so there's certain issues that jump the realm. I wouldn't say purely legal, I would say looks like law. Right? There are things that used to look like law that are now looking political. And that's just a normal process of history, right? I mean, people focus on certain things and they ignore the politics of something. I was talking to a student earlier and I used the example of, I don't know what the percentage, I won't put you on the hot seat, but this is a policy school. I don't know what percentage of Americans live below the poverty line, if anyone knows. But I don't want to give a number, but I mean, let's say 20%, 15%, is that about? I don't know. I hate to have this on YouTube, I tell you. Anyway, that's just a guess, a wild guess. I'm a law person. I mean, I don't think, for the most part, as long as people aren't talking about that as an issue that people are going to change, it doesn't look political. But if you think about it, of course, it's extremely political. You know, as long as people accept something as the way the world is, then it looks like it's apolitical. And law is the same way. It can look apolitical, but ultimately, especially if you're taking the long view, it is about politics. Yep.
I'm going to collect two student questions. So if you both right there could.
All right, so you were talking about conservative adherence to the Constitution and how it seemed, would you call that, sorry, rather inarticulate, would you call that most of the supporters behind the war on drugs and adventurism overseas and nation building have been on the right, with the exception of like Thomas and Scalia and Gonzalez in like 2005. So would you say this is a departure from conservative originalism, or does this go behind the moralistic tradition, or neither, or both?
Great question. And the colleague in front of you.
So within movement conservatism, do you see a sectarian divide between Catholics and Protestants, in particular Protestants evangelicals? I only ask this specifically because despite like the perceived dominance of Protestant evangelicals within the Republican coalition, all of the conservatives on the court right now are either Catholics or heavily steeped in Catholic thought.
Great.
Yes. Okay, so those are both excellent questions. Okay. So when you talk about skepticism about the war on drugs and about a resistance to foreign policy adventurism and militarism and things like that, I mean, what immediately comes to mind is that's libertarians and a libertarian part of the...
I had said that most of the people supporting both of those things seem to be on the conservative right.
Supporting the war on drugs and, yes, okay. So that's also true. Right? I think libertarians within the movement are against that, but obviously moralists are for those things. So there is, I mean, part of what I do in the book is I try not to deny, and this might apply to the other question as well. I have separate chapters on each of the different elements of the coalition. And I think that historically, of course, they have been divided. So libertarians and moralists have been divided on these issues within the movement. And traditionally, Catholics and evangelicals were divided. And by the way, I would add other dimensions. I mean, the religious right used to say a lot of hostile things about free markets. You know, I mean, most of the people who were on the contemporary religious right were Franklin Roosevelt supporters, if you go back to the white working class and things like that from an earlier period. So, I mean, one thing I do try to chart is how those groups, even given their differences, whether theological or policy-based, or even principle, how they came to see themselves as part of the same team. And the central argument in the book is that they essentially talked their way to the idea that they had more in common with each other than their enemies, right? And their enemies are secular liberals and progressives. And secular liberals and progressives were the enemies of the Constitution as this was framed, right? So, in a way, this is artificial. You know, in a way it's artificial, but coalitions in politics are artificial. I mean, they're based either on, the only way that they're held together are, the typical answer in political science is they're held together through political parties, which either uses the adhesive of ideology or side payments. If we win, you'll get this, I'll get that, right? And there's something always artificial about a political coalition. And then the final thing I would say that before just making a comment about the religion on the Supreme Court is that, if you study even going back to Walter Dean Burnham and the realignment theory of politics, all I have to argue is that this held together for a long period. It doesn't mean it will hold together forever. Right? I mean, it could hold together for 30 years. And that in politics, that's it. So far it's been holding together. That doesn't mean that it's going to hold together. But I don't see it coming apart yet. I see rumblings. As far as the justices of the Supreme Court and being Catholic, that's a very interesting thing to me. The traditional thing that people say about this is, and actually, evangelicals have said this themselves. So there's a lot of talk between, there are meetings, there are conferences between conservative evangelical and between Roman Catholic political theorists. And they get together and try to discuss this. And the latest thing from evangelical conservative political theorists and historians and theologians is to kind of condemn themselves and say the evangelical tradition really doesn't have the intellectual systemic richness that Catholic natural law theology has. And part of that is to praise Catholic theology and kind of urge them, their theologians, to try to do better. So they feel like they're lacking in this regard. I don't know how that ends up with all the justices being Catholic, right? But let's say one thing. It's quite possible that everyone is recognized that the Catholic tradition is much richer and deeper. And the evangelicals recognize that that's an issue. Now, the other issue, however, is geographically and educationally, where do Supreme Court justices come from? And they're coming from the Northeast. They're almost exclusively coming from Harvard and Yale. And I just got to think that there are a lot more Catholics in the Northeast than there are in the South and the other parts of the country. And I was trying to think about the Republican appointments. I don't know about evangelical, but certainly he had tried to appoint Harriet Miers, President Bush did, and she had gone to SMU. And I was like, oh, no, 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 you know? I mean, we can't have that. And I think if it weren't just Harvard and Yale, and it weren't just people from the elite of the Northeast, which happens to be much more Catholic, right, then maybe there would be more evangelicals. I don't know, you know, that might change. It may change. But certainly when it just got started, that's definitely how it has played out, as you observed, in an interesting way. Yeah.
One final quick question.
You finally mentioned political parties in the last few minutes here, and I'm wondering how an originalist approach to the Constitution.
Would you mind repeating your question?
I'm wondering how an originalist approach to the Constitution deals with the fact that one of the most important aspects of our government, our politics and the like, is not even mentioned in the Constitution or contemplated in it.
Yes. Okay. So this is also something that's very interesting. Yes, the American founders not only didn't anticipate political parties, but were actively opposed to political parties. The short answer to your question is that in the period I discussed, the 1950s and 1960s, many conservatives, including people like Wilmore Kendall, would say exactly what you said. That parties, the conservative belief is that parties are an excrescence on the Constitution. The founders would have been appalled. Of course, the founders lived long enough to be part of political parties. That's a bit of a problem, right? I mean, Madison and the parties were started essentially by Jefferson and Madison leaving, you know, the Washington administration, and you know they fell into political parties. But conservatives used to condemn political parties and partisanship very openly on an originalist basis in the period I'm talking about. But actually, I do think that there is a strain amongst the natural law people that at least implicitly critiques parties and partisanship, and this is sort of a Republican emphasis on sacrifice and virtue and service. That is a bit of an echo of the old pre-partisan American founding, right? The idea that we are no, you know, as Jefferson said it in his inaugural, right? We are not Republicans or this, we're Americans essentially. That essentially there are people on the right who still talk about virtue and sacrifice, patriotism, right? The problem, of course, is that patriotism has been enlisted as a partisan cause. So I don't think there's any neat answer to your question except saying we're very far beyond that moment in American history, and we were probably beyond that moment even in the later Washington administration, I'm sorry to say. But older conservatives were consciously aware of it and did point it out in a way that you don't hear on the right as much today.
Please join me in thanking Professor Kersch.